Good morning and good afternoon, everyone. Thank you for joining us for Retaining Employees in Healthcare Workplaces, Pay Equity, and DEI. I'm Barb Grangine. I'm an attorney in Husch Blackwell's Healthcare, Life Sciences, and Education Group. I have a specialized focus in labor and employment matters. I'm based out of the Denver office. And joining me today is Tracy O'Brien, who is also a member of our healthcare business unit. And she is also the co-lead of the firm's OFCCT compliance team and a specialist in labor and employment as well. As usual, there are a few housekeeping items before we get started. At the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any questions during the webcast, please submit via the question box. Tracy and I will try to answer all the questions during the webcast today, but if a more complete answer is needed, or if we have too many questions and run out of time, we'll try to answer those later by email. Please do ask questions. That's what makes this more fun and interactive. So we look forward to hearing from you. A PDF of the presentation is available in the program materials folder. This program has been approved for legal education hours. For live attendees, you can report your hours by clicking on the CEU icon at the bottom of the screen. And a certificate of attendance, including the course number, will be emailed to you tomorrow along with a recording of this webcast for watching and sharing when you have nothing better to do. Toward the end of the program, please be sure to complete our short survey. We use your feedback to plan additional programs and to adjust what we're doing here to meet the needs of our audience. So that's it for all of the housekeeping items. Let's go ahead and get started with our program. And we are going to start with a poll question. So the first question for our poll, we just want to know who's attending here today. So if you could let us know what type of employer you represent: a hospital, hospital system, a physician, medical group, any kind of a post-acute organization, maybe you're a life sciences organization, maybe you're a service provider to the healthcare industry, and you might also be part of F, other. If you answer other, we'd love to have you just throw in the questions what it is that you are. So let me give you just a couple of seconds to finish. We have a few more responses coming in. We have a nursing home, assisted living, as one of the people that's identified themselves a little more specifically. Okay, we're still going up a little bit more. We have services for disabilities, health system joining us. Okay, that looks like most everybody that's probably going to respond. And so based on the responses that we received, it looks like our largest grouping is other, and that's what we're seeing here in the questions. We have an FQHC joining us, health system, followed secondly by hospitals and hospital systems. And that makes actually a lot of sense to me, because part of what we're going to be doing today is talking about workforces that have larger numbers of people in them. That's oftentimes where you see some of the pay equity issues that get buried a little bit more. So we will go ahead and go on now to our next slide. So the agenda of what we're going to cover today, we're really going to talk about the equity part of the DEI acronym, and more specifically pay equity. So we're going to start by talking about the pay gap and supporting data metrics. We're going to touch on the current legal developments in the DEI landscape. I'm sure, as you all are aware, and you've probably attended other webinars we've put on, there's been a lot going on around DE&I programs. We're going to cover legal considerations around pay equity, pay transparency, and in particular, what to be thinking about when you're conducting a pay equity audit. There's federal and state law that are covered by those issues. And then we're going to talk about the best practices for conducting a pay analysis and implementing a compensation policy. Okay, so to start with, is pay equity part of your DEI plan? And the answer to that is absolutely. at the heart of any DEI plan is the concept of prohibiting unlawful discrimination and promoting equal opportunity. In the pay equity space, it's typically focused on gender disparities or gender plus another protected characteristic. And it's also important, as you'll hear later on, that to remember that equity goes both ways. So it's not just about women being paid inequitably. Men can also be paid inequitably. And so we'll give you some examples of that. It shouldn't be any real surprise around pay equity because under Title VII, that's been around for a really long time, employers are prohibited from discriminating on the basis of a protected characteristic in employment, and that includes pay and benefits. There has also been a federal Equal Pay Act in place for quite a while that requires men and women in the same workplace be given equal pay for substantially equal work. All forms of pay are typically covered by these laws, including salary, bonuses, stock options, sign-on bonuses, benefits. And what's happening is that the state equal pay laws, such as the Colorado Equal Pay for Equal Work Act, that I'll talk about a little bit more since I sit here in Colorado, have really tightened up the pay discrimination rules set forth in the Equal Pay Act, the federal one, and now include a lot of specific transparency obligations. So I would say the states are really taking the lead at this point in making pay equity a real part of the DEI plan. Tracy and I have gone back and forth. This quote came from somewhere, but then we've modified it, and so it's our words at this point. But we strongly believe that one of the most significant actions that an employer can take in support of its employees is to provide equitable compensation. So that's what we'll be talking about today. And with that, let me hand it over to Tracy to talk to you a little bit about the data.
Hey, thanks, Barb. Hello, everyone, and thank you for attending our webinar today. Barb has discussed a little bit about what the pay gap is and how pay disparities become unlawful when they're based on protected characteristics such as gender and race or ethnicity, as well as if they remain unexplained. It cannot be explained by legitimate non-discriminatory factors. So before we dive into really the legal considerations around preparing a pay analysis in relation to a DEI program, we're going to do a very brief dive into some metrics regarding the pay gap. There's been two reports. I'm going to advance to the next slide. Two reports we will cover, and one is the Pew Research Center report, which was issued in 2023, and it was based on data spanning the period of 1982 through 2022. And as I'm sure most of you could guess, the pay gap decreased over that period of time. In 1982, all women in the aggregate earned about 65% of the pay of men. And in 2022, that number went up to 82% of the pay of men. And while the pay gap narrowed for all women, the Pew report is interesting because it reports that on a number of different other trends, including that the pay gap varies significantly among women of different races and ethnicities. Specifically, based on 2022 data, Black women earn about 70% of what white men earn, Hispanic women 65%, Asian women approximately 92%, and white women 83%. In addition, the report shows that the pay gap really increases throughout a woman's career. So while she might earn approximately 92% of what men earn when she begins her career, over time and as her career progresses, that pay gap increases. And interestingly enough, the report explains that when women similarly situated or similarly educated women are compared with and without children, both groups make less than men, both with and without children. Okay, so on the second report, which we have, We're going to look at a report that was released by the EEOC recently in March of 2024. And it's based on, as many of you probably remember, the EEO1 Component 1 pay data collection. And if you remember it, you probably don't remember it with any fondness. You can recall that the collection occurred in about 2019 and 2020, and it covered pay data and hours reported by race and gender from certain private employers and federal contractors. Overall, the EEOC concluded that in the aggregate, women are paid typically less than men, and that the median pay band for men was one pay band higher than the median pay band for women. And the report has been released by the EEOC. It isn't a report, it's more of an interactive dashboard. And it compares the, sorry about that, hold on a second. Next slide, perhaps. Thank you. Okay, there you go. Here we see the next slide. It compares the median pay band for women and for men in the healthcare industry and all industries. And as you can see by the red asterisk here, when the median pay band for women is about one pay band below that for men in 3 out of 4 of these job classifications. Okay. Now in the U.S., you can see that women dominate the jobs held in the healthcare industry, with 78% of U.S. healthcare jobs held by women. 88% of registered nurses are women. The EEOC's dashboard also supports this. You can see the data here. Let's see. On the left here is a chart, and it's filtered by job classification for female composition of job categories in the healthcare industry for the year of 2018. Here you can see on the far left, it lists the job classification, and the color blue on the bar on the chart represents men, while the orange represents women. We can see, for example, administrative support workers, 90% of them are females. If you look down at professionals, 79% are females. Okay. What just happened to my? Okay, here we are.
Yep, Tracy, yeah. You just flipped it to my slide if you're ready for me to start talking.
No, I'm having a little trouble with my, there we go. Okay, I don't know what happened there. Sorry about that, everybody.
Yeah, no worries.
Okay, so the takeaway is that even though women hold significantly more jobs than men in the healthcare industry, the pay gaps still exist. And while proper identification and remediation of unlawful pay disparities is necessary, as Barb is about to explain, identification and remediation must be done correctly as part of your DEI plan to avoid inviting challenges and potential liability. Barb?
Okay.
Oops, sorry.
Okay, I'll control the slides now, Tracy. Yeah, so here we have, I'll talk a little bit about the DEI legal landscape. Lots of case law in this area. It's been evolving, but I would say there's not really any changes to what private employers should be doing. You know, it's always been unlawful to make preferential choices based on race or gender, except perhaps in the context of affirmative action. And I'll let Tracy talk about that later. But, you know, kind of the seminal case that we've seen recently in 2023 about DEI plans related to the plaintiff, the Students for Fair Admission, versus, I think, both UNC and Harvard. And so essentially the challenge was to college admission programs where somebody's qualifications were considered, and race was a plus factor to kind of put someone over the top to bring them into the program. And the court held that these kinds of race-conscious college admission programs intended to increase diversity actually violate the Constitution's Equal Protection Clause. According to Chief Justice Roberts, the racial classifications are simply too pernicious to permit. Justice Gorsuch wrote that both Title 6 and 7 codify a categorical rule of individual equality without regard to race. And what this means is that there has been significantly greater scrutiny at both the federal and state level of the lawfulness of voluntary affirmative action plans and DEI plans that seek to increase diversity. Again, affirmative action programs and plans being their own separate beast. So for private employers, I think there's a question of whether you're a federal contractor and you have an affirmative action plan. If you're not, then I don't think that this necessarily changes what you should be doing with regard to trying to increase diversity. And I also think that the Supreme Court in this case really focused a lot on university admissions being what it referred to as a zero-sum game. So there's only a certain number of people that are going to be admitted into a university class. And so because of those limitations, the court found it to be fundamentally unfair and violative of the Constitution for race to be considered as a factor in admitting someone to the program. For private employers, what I would say to you is that Title VII has always prohibited you from making employment decisions based on any protected characteristic, whether that be race or gender. And private employers can and should continue to seek increased diversity in their workforce by setting aspirational goals, so not quotas, but aspirational goals with regard to diversity, equity, and inclusion. And those goals can be reached in any number of ways, again, without a hiring quota or without getting rid of men in order to replace them with women, which would be unlawful. And you probably all realize or recognize some of these things. Maybe you have a mentorship or a pipeline program. Maybe you're looking more carefully at how broadly you're advertising and recruiting for your positions to make sure that you're getting advertisements and recruiting out to a good cross-section of your community, and you're not necessarily just going back to the same well in terms of finding people to hire. And then additionally, as in your workplace practices, taking any complaints about discrimination or unlawful treatment seriously, and making sure that you're providing a fair and equal workplace for everyone. We had a couple of cases here to just highlight for you quickly. That this first case is a 2021 case, Duval versus Novant Health. And in that case, a white male executive was awarded $10 million in punitive damages by a jury. After hearing the evidence, the jury concluded that he was actually terminated, his employment was terminated during a phase of a DEI plan. So that his employment was terminated, and two employees, a white female and a black female, were elevated to fill his position. And based on some of the data in this workforce, 82% of the workforce was female, but only 4% of the females comprised leadership positions. And there was evidence presented that this employer wanted to have its leadership reflect the community served and increase the number of women in leadership. Certainly a laudable goal, but the way that they went about it was problematic because they had an outside consultant that basically recommended a certain percentage point increase in Black leaders. And that change happened dramatically as part of this DEI plan. And there was evidence that it was actually intentional to get rid of or demote or alter the relationship with the white male employees so that the female employees could take their place. And they also, this employer didn't have any kind of a reason to articulate a legitimate reason for the termination of this white male executive. So without that, really the conclusion that the jury reached was that this was just a concerted effort by this employer to replace the men with women, and that cost them $10 million. So I'm sorry about all the words on this slide, but I did want you to have this case as a reference point. The other case that I wanted to mention is a case from 2022 where the EEOC was the plaintiff. And in this case, the EEOC filed a complaint in federal court against the Maryland Department of Transportation on behalf of a male employee. This case ended up settling for $40,000. And the evidence established that this male employee who was in a community relations role, it had a long career, and at various points during his career, he was paid less than female employees who had the same role in a different district of the Maryland Department of Transportation. And that as he changed districts and progressed through his career, the women, it turns out that women filled his position behind him, and those women were actually making more than he was at various points in time. And there were no factors, according to the EEOC, that supported this unequal pay, that, no difference in education. In fact, the factors probably supported that this male employee should have been paid more. So for example, at one point, he was doing this community relations role for 2 different districts, and yet his pay didn't reflect that additional workload. The EEOC's press release that came out with the settlement of this case, they acknowledged that pay disparities most often affect women in the workplace, but reminded us that the law applies to men as well, and that fundamental fairness dictates that employees receive equal pay for equal work, period. And so absent a completely homogenous workforce, every employer is at risk of having someone who is paid less than someone else for doing the same work. And that's likely going to trigger equal pay violations unless there's one of the safe harbor exemptions or explanations applicable in that situation. Under the federal law, and we'll talk about this a little bit more, those would be something like a seniority system, a merit system, a system that measures earnings or by quality or quantity of production. So for example, if you have a male employee who's making more because his performance evaluations have been consistently more, that it could be a reason to explain the disparity that takes it out of the purview of being an equal pay violation. Under the federal law, one of the factors that you can use is that the disparity is based on any factor other than sex. And as Tracy will talk about in a few minutes, that exemption is basically as broad as it can be. It swallows the rule really under the federal law, because somebody can often articulate some reason other than sex that would support the pay disparity. As you will learn during this presentation, while that's the position that the federal law takes, that's one of the loopholes that the state laws are closing to make it easier for someone to bring an equal pay claim. Tracy.
Thanks. Okay, another challenge to DEI programs is with regard to what's known as the diverse slate hiring policies. This goes back to, it's also referred to as the Rooney Rule. The Rooney Rule, if you're familiar with it or not, it was named after Dan Rooney. It was adopted in about 2003. Dan Rooney was the Pittsburgh Steelers coach, who was also chair of the NFL DEI committee. Now, the rules are revolved over time, and it now includes women, but it requires member teams to interview 2 external minority candidates for each executive position, GM position, or head coach position. And like I said, it was expanded to include women as part of its diverse slate. There have been 2 recent challenges to the Rooney Rule. One is American First Legal sent a letter to the EEOC in 2024 requesting that the EEOC investigate the NFL and member teams relating to their use of the Rooney Rule They allege that the NFL conducts sham interviews and thereafter, and consequently deprives other qualified individuals of obtaining interviews and job opportunities who do not self-identify as a minority. The second challenge was brought by former head coach of the Miami Dolphins, Brian Flores, who filed a class action lawsuit against the NFL and certain member teams, alleging that there was a pattern or practice of mistreating Black coaches, including subjecting them to sham interviews without the intention of hiring them. So those are two challenges to the diverse slate candidate rule. And Barb mentioned the Scottish UNC Harvard case briefly just prior to this. And historically speaking, expanding outreach to increase minority candidates has been considered acceptable and with little legal risk associated with it. But the lawfulness of using a diverse candidate slate now has been called somewhat into question by the SCOTUS opinion, the UNC Harvard case, the college admission case, where Chief Justice Roberts characterized college admissions as a zero sum, with where a benefit is given to some but not others, and then that disadvantages those who do not receive the benefit. So with regard to diverse candidate slates, you should be aware of how you're conducting that and what you're doing, and the use of caps on perhaps candidates or a specific numeric number for how many minority candidates are being interviewed, etc. Also be aware of ongoing development relating to state legislation. Several states have passed laws restricting DEI programs, banning funding. Most of these occur at public institutions. The laws apply to DEI programs in public or government institutions. They also ban mandatory training programs in those institutions that promote what's described as divisive content. The state that has most recently passed a law would be Alabama. So as this is an ongoing legal issue, and you should be aware of what's going on in the state where you have a presence or a facility in that state. Let's see. Barb, I think the next slide is yours.
It is. So just some takeaways and programs at risk to summarize what we've covered here. It is unlawful to discriminate against one group over another. It's also unlawful to protect one group over another. So some key things to consider are avoiding numeric goals and timelines for achieving diversity in your workforce, unless the employer is a federal contractor. And I mentioned Tracy will cover that in a little bit more detail later. You need to understand that these efforts to change the composition of your workforce with respect to diversity is going to take time if it's done properly. That's one of the learnings from the case that we discovered or that we talked about earlier, that when it happens so quickly, it raises a lot of suspicions that the diversity efforts are being taken in a quota type of a way instead of naturally reflecting the environment around your workforce. Your job as an employer is to hire the most qualified candidate, but make sure that you're conducting robust outreach so that you're going to capture the most qualified candidate in any different part of the community and not just from one feeder school, for example. And then I know that diversity goals are often baked into compensation or performance evaluations for executives. Be sure that if that's something that you're doing, that there is a way to measure those goals that is lawful and non-discriminatory. And so again, if you have numeric or timeline goals built into your executive compensation, you're essentially incentivizing your executives to do what legally they should not be doing by trying to push to receive some, numeric increase in diversity in the workforce so they can get more money. Again, in conclusion, I think that while we're going to see more activity in this area of the law, certainly, employers should understand that efforts to create and foster inclusive and diverse workplaces and to prevent discriminatory practices continue to be legal and encouraged. They're really, really important. It's just a matter of how you are doing that. Okay, Tracy, a little bit about the law.
Yes, yes. Okay, so we have federal laws and state laws that relate to pay equity. We'll be discussing Title VII and the Equal Pay Act with regard to federal laws. And one of the most important aspects of a pay analysis is determining which employees are comparable. Which employees are going to be compared to determine if there are pay disparities. So the law really dictates the determination of which employees are comparable. It defines the meaning of similarly situated employees, right? So Title VII of the Civil Rights Act of 1964, as Barb mentioned, has a pretty malleable, broad standard. It requires comparison of pay among similarly situated individuals. To be similarly situated, employees must be able to perform all of the essential or relevant or material functions of the job. That terminology, essential, relevant, material, has been used in different places, but that's basically what you're looking at. The relevant factors to be considered relating to pay decisions are many. It includes the skills that's required, the efforts, responsibility, minimum qualifications that you have in your job description, right? Education, licensure, certifications, tenure in the company, years of experience outside the company, things like that. Going on to the next slide, when we're talking about the Equal Pay Act, the Equal Pay Act has a slightly different standard, right? They require employees be paid equal wages for equal work performed under similar working conditions and on jobs that require equal skill, effort, and responsibility. And the factors that allow for differences in pay among comparable individuals are seniority system, merit system, and any factor other than sex, as Barb mentioned earlier, as well as a system that measures earnings by quantity and quality of production. So that too is very broad. What's important is that the law defines the meaning of what is a similarly situated employee. But the job of the HR department and the talent acquisition team is to then take their knowledge of what they know of the requirements of the job and other information such as what's included in your job descriptions, what are the minimum qualifications, and identify those individuals that should be compared with respect to pay to determine whether there are disparities. Because in the event of litigation, of course, that will be one of the important issues as to whether the individuals that are being compared for the purpose of pay disparity are indeed comparable. Excuse me.
So, hey, Tracy, before you go on, if an employer discovers a disparity, can they just knock down the higher compensated person, just level set the compensation at a lower amount?
No. If there is a disparity, you can never decrease the income of one or either party. You have to increase income or pay. And usually, if there is an Equal Pay Act claim, there's most probably a Title VII claim too. Are you taking over the slides, Barb?
Oh, I can. All right, so here's our next poll question. The question is, have you as an employer conducted a pay audit to identify and correct pay disparities? We're looking at timing questions here. Yes, you have in the last 5 years. Yes, you have in the last 2 years. No, you never have. And then I have a category for other again, because I'm always curious about the potential answer that I've missed when I put in these poll questions. So let's pause for a moment and poll the audience to find out how recently you have conducted a pay audit for the purpose of identifying and correcting pay disparities. We've got a few more responses coming in. So far, I don't have anybody telling me other what we've missed as an answer. Let's see if our response percentage continues to go up. Yep, it's going up. It's going up. Okay, so here's one where the other is that they are doing this by groups within the organization, and that makes sense. It's kind of bite-sized pieces to get to where you need to be. You might not do it for your entire workforce, but you would be doing it in a particular segment of the workforce, particularly where you have people doing the same job or substantially similar work. Here's another one that's currently doing it in the context of how long has someone been with the organization. It sounds like that might be on the theory that if you stay within a company and just take the regular pay raises that come along, you're potentially making less than if you just went and found a new job elsewhere. And that's a long-going, a lingering situation, and it's really a symptom of the problem that we have here, because you may have a long-term female employee who's done her work and received her regular bonuses or compensation increases, but then when you go to the market to hire someone who turns out to be a male, you have now likely an equal pay issue. Okay, so it looks like our percentages are slowing down for our responses. And I'm realizing now the fallacy in my question. If you've done it in the last 2 years, you've also done it in the last 5 years, but I'm hoping that nobody thought through the question that much. So it looks like really, about half of the folks attending are recognizing that this needs to be done, and they're in the process of doing it or have done it somewhat recently. I'll talk in a little bit about how often you should consider doing this, and if you happen to be in the 5-year category, that might not be often enough given the legal landscape that we're seeing in some of the states. Here's another where it was a survey about tasks for a unique position and trying to find comparative information. So yeah, we'll definitely talk about that when we talk about pay audits, but half the battle is figuring out who's similarly situated, and spoiler alert, the job title is really kind of irrelevant. So we'll get to that. Okay, so I'm going to talk just briefly, again, I do sit in Colorado. I'm going to talk about the Colorado Equal Pay for Equal Work Act, which at the time it was enacted in 2021 was kind of the farthest reaching equal pay transparency legislation. I think we even out California to California on this one when it was first enacted. And so this is intended to just kind of give you an idea of what might be coming to a legislature near you as the states step in to try to promote pay equity with the federal government not really doing all that much. So in Colorado, this act prohibits discrimination based on gender alone or with another protected status by paying less, so far it's pretty much the same as the feds, for substantially similar work. So equal pay for equal work in Colorado does not mean equal work, it means substantially similar work, and that you're considering things like skill, effort, and responsibility. So the art that HR is engaging in is who is doing substantially similar work. The objectives, the stated objectives of the Colorado law are to increase pay equity and transparency. We have new notice and record keeping requirements, and we have a incentive to regularly self-audit. You get an affirmative defense to some of the damages that could come out of one of these kinds of claims if you've conducted an audit within the last 2 years prior to someone bringing an equal pay case. We also in Colorado ended up with a lot of transparency provisions. Some things are obvious, like don't ask somebody how much they used to make at their last job, But this was one of the first in the country to say, and when you're looking for someone to fill a job, you've got to tell everybody the range of what you're going to pay for that position. Another thing that's interesting then here in Colorado is that you will see that the pay differences, the exemptions, mirror what we talked about under the federal law in terms of seniority, merit, the geographic location where the work is performed probably makes some sense. We're not entirely sure what geography means. Travel could also be a consideration for somebody doing substantially similar work but being paid differently. But what's missing here is that any basis other than sex factor that is available under the federal law. And Colorado did that intentionally. It's not an oversight. The Colorado legislators who drafted this legislation specifically said that Colorado's adoption of a textually broader equal pay mandate comports with its express legislative purpose, giving Coloradans a broader right to pay equity than exists under federal law. Pay transparency, again, our law contains a variety of pay transparency provisions that protect your employees' ability to talk with each other about compensation, to share information, to refuse to tell you how much they used to make on a different job, and you cannot force them to, and you can't retaliate against them. Then the other feature of the Colorado law on pay transparency is that employers have to make an effort to make known every job opportunity, and that's a specifically defined thing, to all employees on the same calendar day before you've decided who you're going to pick for the job. And those job opportunity postings have to disclose the hourly wage or salary or a range along with a general description of the benefits. So everybody is going to know the range into which someone has been hired when they accept a job opportunity with your organization. And you have to hang on to all this wage history and job description information for a period of time, which I think is probably exactly what the plaintiff's bar was looking to have happen. I mentioned this earlier, we do have a specific defense as a compensation audit. It is a limited defense. It doesn't save everything, but if you've done your audit correctly, you shouldn't be facing an equal pay claim in the first place. Let's see. Colorado says it's working. This kind of a law is working here. And so according to the Women's Foundation of Colorado in a March 2024 report, Colorado's national pay equity ranking has jumped from the 21st smallest gender wage gap to the 6th smallest among the 50 states. Women working in Colorado full-time have increased from 78 cents to 85 cents for every dollar paid to men. And the gender wage gap, according to this study, is closing because women are being paid more, not because men are being paid less. Colorado, the rate of closing of the gap is also 3 times faster than the rest of the United States, with California and Washington, who have enacted similar laws, seeing similar results. So it seems to be working. Other states, yeah.
Before you move off of the Colorado law, how does it apply to remote workers?
Yeah.
If you've got remote workers in Colorado, yeah.
Yes. Well, you're comparing that remote worker to others in Colorado. So if you have one worker in Colorado, you probably don't have somebody that's doing similarly situated work or substantially similar work. If you do, you probably have a geographic argument because someone in Colorado is sitting differently than someone in a different part of Colorado or perhaps in a different state. I also don't think that these state laws are going to be able to reach across state lines in terms of comparing employees in different locations. I think that's potentially a constitutional issue that we'll see come up. Thank you. That was a good question. So other states are following the lead, enacting pay equity laws. All of them are a little bit different. Washington and California have a lot of teeth to them. Washington in particular, a private individual can sue if they think that they are damaged by a failure to be transparent about pay. That goes even farther than Colorado can. So Washington has taken the lead on that one. But we expect there will be more and more of these laws rolling across the country. Okay, Tracy.
Federal contractors, right? So word here with respect to federal contractors, as if there's any federal contractors on the call, and it looks like there could be, that the law, as you know, the law imposes affirmative action requirements on federal contractors to create written affirmative action plans and to perform certain statistical analyses on underutilization of females and minorities, as well as adverse impact or disparate impact in employment activity. And employers that meet those thresholds of having a single federal contract of 50,000 or more and 50 or more employees are subject to the OFCCP jurisdiction. That's the Office of Federal Contract Compliance Programs jurisdiction. Now, there have been recent changes in the interpretation, in OFCCP's interpretation of their regulations with regard to evaluation of compensation systems under Title 41 CFR 60-2.17B3. And the obligation there is to evaluate compensation systems to proactively ensure and to proactively identify pay disparities based on gender, race, or ethnicity. Now, nowhere in that regulation, and that is the full extent of the regulation, nowhere in that regulation does it require federal contractors to perform a pay analysis. But that is indeed how the OFCCP is interpreting it. In the directive issued in 2022, they signaled that they would be changing their interpretation, and indeed in August of 2023, their updated scheduling letter and itemized listing, which is the letter that federal contractors receive from the OFCCP when they have been selected for an audit, will impose an obligation on federal contractors to proactively have conducted a compensation analysis to identify and correct disparities in pay. And in the audit letter, they will ask the date of any pay analysis, the type of pay analysis done, whether it included all employees or excluded certain employees, and the types of pay that were covered. It will also, as part of the audit, federal contractors are required to report their pay data and compensation, including base pay, as well as bonuses, overtime, commissions, et cetera. So there is an obligation there on federal contractors to do an analysis of some sort that would allow them to determine and identify pay disparities and correct them. And one of our recommendation is with respect to federal contractors that they actually conduct two pay analysis. One would be privileged, which Barb will discuss in a few minutes, and the other one would be non-privileged, so that after you have conducted your privileged analysis, after you have corrected all your pay disparities, and then that was in that non-privileged one, if it's required to be submitted to the OFCCP at some point, you'll be able to do so. The next slide. Okay, healthcare providers and federal contractors, healthcare entities that perform services used by the federal government, either through a direct federal contract with the government or as a subcontractor indirectly with the government, and that satisfy certain jurisdictional thresholds are considered federal contractors and subject to OFCCP jurisdiction. However, hospitals or healthcare providers that are simply participating in TRICARE are exempt from this requirement, assuming there's no other federal contract involved, which subjects them to OFCCP jurisdiction. Reimbursement for services under Medicare Parts A and B, and provider agreements under state Medicaid plans. That does not subject healthcare providers to the OFCCP jurisdiction, because those types of reimbursements are considered federal financial assistance. Now, healthcare providers may have other contracts, right, that subject them to OFCCP jurisdiction. Those other types of contracts can be a number of different types, including teaching hospitals who perform research pursuant to a federal contract, contracts with perhaps the Federal Bureau of Prisons for treatment of prisoners, and of course contracts with other agencies to provide medical supplies or other services. Okay, Bart, this is your.
Actually, this is you, Tracy.
Okay.
Keep talking.
So we're finally get to perhaps the meat of the presentation today. How is an internal pay analysis performed? Well, there's a number of discrete steps to performing a pay analysis. And first, you really should identify, the scope of your pay analysis, and you should be considering your budget and how often that you want to be reviewing pay. Once you do define your scope and budget, you want to conduct the internal pay analysis under privilege. And it's given the limitations on the attorney-client privilege, which Barb will discuss in a couple slides later, it would be best and probably prudent to use outside counsel. Once you have decided to conduct an internal pay analysis under privilege, you want to start collecting the relevant data, including demographics. The type of data that you will be collecting is going to be, of course, employee data and demographics. You want to, and if you have it digitized, and this is the important part, you have to figure out what factors influence pay, and which of those factors you have digitized, so that you can use it as part of your analysis. The types of factors that influence pay, of course, are going to be tenure. You're most likely going to have that. You're most likely going to have the date of hire. You may have digitized performance evaluations and performance reviews, and know where people fall on that. Pay bands is another data point that will be collected and used to evaluate compensation. As we discussed earlier, you're going to want to group your employees and your similarly situated employees so that you can compare employees. Job title may or may not be relevant. Job titles, as Barb mentioned, don't always indicate who is similarly situated. However, by the same token, it's usually unlikely that you're going to be comparing the pay of people with different titles, and you're certainly not going to want to compare people with different titles who aren't performing similar jobs with similar duties and similar responsibilities and similar opportunities for advancement. You're not going to be wanting to compare an hourly worker or a non-exempt worker with an exempt worker. So there's a lot to consider in how you group your employees. Once you have your data compiled, you know what you have, you know the factors that you have digitized, and you'll be able to determine what type of pay analysis you will be able to conduct. Do you have enough factors to conduct a regression analysis? Or is it going to be a rank sum analysis? Or is it simply going to be a cohort analysis? Once the analysis is generated, you will then need to look at the different pay disparities within each group of employees that are being compared, and identify reasons that support the pay differences among the employees. These are your affirmative defenses, right? This is, well, this person has greater tenure, this person has more education, receives pay, this person has X experience over this person. So once you identify those reasons, those legitimate non-discriminatory reasons for pay differences, you want to document those differences. And then if you're still left with pay disparities, you have to take a look at those, identify whether they're unexplained, and if so, consider either remediating that pay disparity, or take a look at the job and see if the jobs really are similar, whether there's a change needed perhaps in job title. Barb, this is your slide.
Okay. Yes. So in terms of attorney-client privilege, Tracy just outlined for you the process, and you are basically going through your data and being very honest. It's a self-reflective process that you're going through, and the information that you're gathering and the conclusions that you're reaching may very well be admissions of a problem. And so that's why you really want to have the attorney-client privilege so that you can self-reflect, admit problems, be candid and open about it without being worried about a plaintiff's lawyer getting a hold of your conclusions until you've had such time to clean it all up. And so the rationale for having an attorney involved, I think, is pretty straightforward and is generally understood by most clients. But the issue comes up when in-house counsel is the lawyer that's being involved in the pay equity analysis, because in-house lawyers, and they know this very, very well, wear multiple hats, and depending on which hat they're wearing, or if there's a dispute over which hat they're wearing, there could be a risk that the attorney-client privilege created in connection with in-house counsel would be considered to be waived or not attach at all. And so the advice that you're getting from in-house counsel or from outside counsel has to be for the purpose of obtaining or rendering legal advice or services. It has to be from a professional legal advisor that's acting in the capacity of a legal advisor. So if the in-house counsel is wearing also their business hat, thinking about budgets and compensation analyses and broader business impacts to the organization, that's not necessarily the legal advice around what are the potential legal claims and legal issues that arise from pay disparities. The communication has to be in confidence, and it has to be to the attorney's client. So again, whether it's inside or outside counsel, you need to limit the distribution of information to a core group of people who are working on an analysis. Email is always dangerous. If you're using email, make sure that you're very clearly marking it as being privileged, that the lawyer is involved in the email, that the lawyer is actually assisting in directing you as in HR, on gathering the information, assisting you legally in analyzing what similarly situated would look like, assisting you in analyzing whether one of the exemptions apply, and if not, what do you do to fix it. There are limitations on the attorney-client privilege. I think it's generally what I just covered. So if the lawyer is a business advisor or a negotiator, wearing a different hat than just a lawyer, you are putting the privilege at risk. And you're also risking at some point that the corporation can waive the attorney-client privilege. So maybe you've done everything right and you have the analysis and it's privileged, and perhaps you haven't gotten around to fixing things yet. If you have an equal pay claim and you say, well, wait a minute, we investigated it, there's no such claim, you've just placed that investigation at issue, and you've potentially waived the privilege related to that investigation. So this is, as Tracy mentioned, we often recommend kind of doing it in two stages. Let's have the good, bad, and ugly disclosed. Let's have a plan to fix it. Let's fix it. And then perhaps conduct a second audit, run the numbers again, and this time the data is clean because you've cleaned up things up and you don't have any more issues. And then that report is what you're using as a defense to a lawsuit or other investigation you would need to produce it. Okay.
This is yeah. Okay. Concluding a pay analysis. The most important thing, of course, is maintaining and documenting legitimate reasons for any pay disparities. That's going to be important if they're down the road, if that information is needed. It's best for you to be able to retrieve that information. You should maintain privilege when it comes to this type of information also. You want to promptly remedy any unexplained pay disparities or at a minimum, consider implementing a detailed and a plan for remediating pay disparities over time, if necessary, due to budget concerns. And as we've mentioned a couple times now, do consider preparing a non-privileged pay analysis as well as an internal privileged pay analysis, especially if you are a federal contractor subject to compliance obligations, where there is the very real possibility of having to disclose a pay analysis. Barb?
Okay, so to bring this home as we're at time, some of the other things that you're thinking about as you're looking at your pay discrimination and risk issues, make sure that everything you have in writing about it, your handbook information, your compensation plans, your promotion policies, reflect these principles that we've been talking about with regard to equal pay. Job descriptions are critical here. That is not dispositive, but it certainly is one way to identify whether positions may be similarly situated. So job descriptions are really important in lots of different contexts, including here. Pay grades and bands are something that larger employers use quite frequently, and I think that's something that employees in larger settings certainly expect. You need to make sure the people that are setting the pay, giving the raises, all those kinds of things are trained in what they should be doing and what they should not be doing. And then be sure to document the reasons for any pay decisions going forward. Okay, so we have had a few questions, and I think we are out of time. So we'll try to give you a response in an email back to you. And I have just a few closing comments. So as a reminder, this program has been approved for legal education hours. To report those hours, you click on the CEU icon at the bottom of the screen. I'm seeing a few people saying that the CEU icon does not appear to be working, so we'll be sure to take care of that on our end and get you what you need to apply for credit. Certificate of attendance, including the course numbers, are going to be sent out to you with a recording of this webcast, and please complete our survey. And with that, this concludes our webinar. Thank you very much for spending an hour with us today.